Will you remark further on the amendment before us? Representative Sampson of the 80th.
Good evening, Mr. Speaker. I haven't seen the amendment just yet. I'm waiting for it to be distributed. I have an understanding about what is in the amendment, and I understand it'll be a voice vote regardless, we will certainly debate the bill after the amendment is voted upon. Thank you, Mr. Speaker.
Thank you very much, sir. Will you remark further on the bill before us? If not, let me try your minds. All those in favor, please signify by saying aye. Aye. Those opposed, nay. The ayes have it. The amendment is adopted. Will you remark further? Representative Scanlon.
Thank you, Mr. Speaker. This amendment is a strike-all amendment, but these bills are very familiar to those of us who are on the Insurance Committee. There are three mostly technical bills from the Insurance Department that they have brought forth to us today. We can have a discussion of that, as I'm sure my friend, the ranking member, and I will have over the substance of this bill, but I believe this is a good bill that does good things for the state of Connecticut and our insurance industry, and I look forward to my colleagues hopefully supporting this bill. Thank you, Mr. Speaker.
Will you remark further on the bill as amended? Representative Sampson of the 80th, you now have the floor, sir.
Thank you again, Mr. Speaker. So the bill we have before us is a pretty lengthy bill. It's 46 pages long. It's a little over 30 sections. And it is one of those occasions where we're taking several bills that passed out of the committee and some other amendments, and we're combining them into one omnibus bill. This is something that concerns me when it happens, because a lot of times there are sections in bills that we appreciate and there are sections that we don't like quite as much. And rather than being able to vote on these things individually, we are put in a position where we have to make a decision about whether the whole is greater than the sum of the parts. And as a result, I think what we ought to do is take a few minutes and just review the parts of this bill. And I'm going to start by just asking about sections 1 through 3. I understand that these sections have to do with the captive insurance industry in Connecticut. Captive insurance is something that is an industry that is very valuable to the state of Connecticut. In recent years, we've made great strides in encouraging the growth of the industry, and I think it's been something that has been beneficial to our state, even when we're have a declining economy. And for that reason, I want to see every possible avenue explored to make sure that we do our best to responsibly grow the captive insurance industry in our state, but also do it in a way that makes sure that we provide the protections for consumers that are absolutely necessary. So this first 3 sections comes from a bill that came out of the Insurance Committee unanimously that required the paid-in capital for captive insurers be reduced from the requirement in Connecticut of $500,000 to $225,000. And this was in an effort to have us compete with other states that have since reduced their amounts also. I have a concern, though, and that is that the simple bill that was 10 or 11 lines that passed out of the committee unanimously that did that one function has now been presented to us in this form as 3 sections that have added more information and more changes to how the captive insurance industry will be treated. And I have to confess, I'm not an expert on this subject. I serve as the ranking member of the Insurance Committee. I try and do my due diligence to make sure I know what I'm voting on every chance I get. We have a committee process that we follow in the legislature for the express purpose of making sure that there are public hearings, there are opportunities for people to review legislation, talk about it, decide what's good and bad, and then decide up or down whether it's going to go forward. For it to come to us at this late stage, I got this language just today, saying that it's something that is different from what was presented to me, is very disconcerting. And I'm not happy because I want to see this bill go forward as a positive step for the captive insurance industry in our state. But I can't, in good conscience, know whether I'm doing the right thing by supporting those sections. So the first section has to do with something called dormant captive insurance companies. And I can only guess what that means from the title, which is that these are captive insurance companies that are no longer active. Through you, Mr. Speaker, I'm hoping the chairman of the Insurance Committee can tell me exactly what Section 1 does and how it affects dormant captive insurance companies.
Representative Scanlon.
Through you, Mr. Speaker, my good friend, Representative Sampson, is absolutely correct. The first section does deal with dormant captive insurance companies. What is a dormant captive insurance company? It's basically a company that is still paying out claims, but they're no longer collecting premiums. And so for whatever reason, a company wants to hit the pause button, but they don't want to completely dissolve their company, they can go dormant and do exactly what this bill lays out. And what Section 1 is completely about is the process by which a company could go dormant in order to not dissolve the company. Through you, Madam Speaker, or Mr. Speaker.
That's all right. Representative Sampson.
Thank you, Mr. Speaker. So my understanding from that is that a dormant captive insurance company is one that is no longer active. Maybe they've hit the pause button because their industry or their business is not in the same place it once was. This seems like a reasonable mechanism. I'm curious about Section 1, lines 24 and 25, though, that say that there's still a requirement for what their finances are. I'm wondering if the chairman can let me know what is required to remain as a dormant captive insurance company in Connecticut.
Representative Scanlon.
Through you, Mr. Speaker, not less than $25,000. Through you.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman for that answer. So on to Section 2. This appears to be the section where we lay out the different requirements for captive insurance companies. And I notice in lines 46 and 47 that it says that we are reducing that requirement from $500,000 to $225,000 as we talked about. And that's the part that I remember from the Insurance Committee, the bill that we passed unanimously out of the committee, thinking this is a good idea to promote the captive insurance industry in our state. There's also some requirements for some other types of captive companies. But one thing that concerns me is that in lines 80 through 88, there is some language here that was not in the original bill that says the commissioner shall have the discretion to allow a captive insurance company to maintain less than the required unimpaired paid-in capital. Through you, Mr. Speaker, Mr. Chairman, does that mean that that $225,000 requirement is not absolutely required, that the commissioner can actually choose to change that number to whatever they might like? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, that is not my understanding, given the way that it's worded in the very first line, line 80, notwithstanding any other provision of this section. My understanding from what the purpose of lines 80 through 88 is that we are losing in a competitive world that we live in with the insurance industry through other states, through regulation. When other states lessen regulations, sometimes we are not always here. We're not a full-time legislature. We're a part-time legislature. This gives our commissioner, who is every single day, whether it's the current commissioner or the next commissioner, whoever our commissioner is waking up and going to sleep with one goal, which is to help our insurance industry prosper. And my understanding of why we laid out section or line 80 through 88 is to simply give him or her as commissioner the tools to use their discretion to do things beyond what is also laid out in the lines that are throughout this section from 32 through 80, notwithstanding those lines. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. Not to disagree with the chairman, but I think that the language is very, very specific, and it says exactly the opposite. It says notwithstanding any other provision in the section, which means that forgetting everything else, it says the commissioner has this discretion, must consider, of course, the type, volume, and nature of the insurance or reinsurance business and so forth, but it does give the commissioner complete and utter discretion to decide what that paid-in capital amount is. And I think basically makes the rest of that section unneeded. And it's not exactly what we agreed on. I'll repeat, I don't know if this is a good thing or not. Is it a good idea to give the insurance commissioner as much discretion as possible to make sure that we invite as many businesses in to operate in our state? Yes, I think so. The question is, why didn't we have that conversation before? We had a bill in the committee that was brought to us to drop the limit from $500,000 to $225,000. We did it. We voted on it. We debated it. We heard testimony. So why is there something before us now that says something totally different, and we're forced to make a decision on it without any of that information? I don't know that anyone in this room is an expert on captive insurance or has enough knowledge to know how much discretion the insurance commissioner should have. There's also Section 3, which is completely new, and it has to do with this concept of cells, about how certain captive insurance companies can break into parts, or the word I think spawn is in here, to spawn other cells. Again, this might be a completely good provision that allows a structure to exist for a captive insurance company to control other captive insurance. I read through it several times. It sounds reasonable to me. But again, without public hearing testimony, without expert direction from the industry and the public, how can we make a decision about whether this is right or wrong? I'm just going to move on to Section 4 for now, although I do want to come back to Sections 1 through 3 in a moment. Through you, Mr. Speaker, can you let me ask the chairman what Section 4 hopes to achieve? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Madam Speaker, Section 4 is very simple. Last year, in 2016, those of us who were in this body at that time voted to allow short-term care policies to be sold on the individual market. This simply allows them to be sold in the group market. Through you, Madam Speaker. Mr. Speaker, keep doing that.
Representative Sampson.
Thank you, Mr. Speaker. This, I recognize, this is some legislation we did pass out of the committee also. I think it is a good provision that would open up the marketplace in the state to sell a product. We actually worked on this in the previous session, and I understand that this is just some fine-tuning to allow that to go forward in the best way possible. So on to Section 5, which I understand has to do with some updates to HMO coinsurance plans. Again, this bill has over 30 sections and affects a lot of different types of policy in the insurance industry, and I understand it's late tonight, and I don't want to be spending a lot of time standing up here speaking on this particular bill, but it is a lengthy bill, and I think it's the kind of bill where we absolutely need to investigate and make sure that what's before us is legitimate. So, through you, Mr. Speaker, would the chairman describe Section 5 for me and what it accomplishes?
Representative Scanlon.
Through you, Mr. Speaker, Section 5 allows HMOs to charge co-insurance. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman for that. So am I to understand that HMOs in Connecticut can currently not use co-insurance? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, yes, that is accurate. The only thing HMOs can charge as of today in Connecticut is copays. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. Just for the benefit of the people in the chamber who probably don't have a tremendous insurance background, would the chairman describe to me what the difference is between a co-insurance and a co-payment? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, to, I guess, put it in 1045 layman's terms, co-insurance is where you're splitting the cost with somebody. Copay is something that you pay towards something. So most people are familiar with the copay. You pay $5, $10, $15, $20. A co-insurance would be that your employer perhaps pays 60%, you pay 40%. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman for that answer. So if I'm right, that means that coinsurance is really the percentage of the cost of the service that is shared by the insurer and the policyholder, while a copayment is the dollar amount that a policyholder might pay for that particular service. And I just want to confirm that's correct. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, that is correct. Coinsurance is a form of cost sharing. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks again to the chairman for his patience in going through this bill with me. So, Section 6 is the next section, and it has to do with codifying a department bulletin, and it's identified as Bulletin PC 66, which my understanding, and I won't even ask a question about this, I think it's pretty clear from the bill. It basically says that anytime a policy is offered that is going to reduce certain types of coverage, they have to be notified in writing. I think that's a very reasonable provision and something I'd like to see pass and become law. So on to sections 7 and 8. I understand these have to do with the Insurers Rehabilitation and Liquidation Act. And again, through you, Mr. Speaker, if the chairman would mind just telling us what that act is and what this section of the bill, rather these two sections, 7 and 8, hope to accomplish.
Representative Scanlon.
Through you, Mr. Speaker, and I believe my friend Representative Sampson is going to like this, but we removed some of the provisions that had to do with our compliance with Dodd-Frank, given the sort of clear nature of what's going to happen with that law down in Washington. We changed this law to no longer reflect that specifically. And basically what it does is when a company is in supervisory mode within the insurance department, so when the insurance department is supervising a company for various reasons, whether they had not enough capital, whether they had a complaint against them, this basically governs the supervisory nature of when the commissioner is supervising a company. As Representative Sampson said, it's purely technical with regard to the insurance rehabilitation and liquidation process within the Department of Insurance. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman for that answer. So am I correct that sections 7 and 8 essentially transfer some of the regulatory authority that used to be controlled under federal law to our state and to the insurance department specifically to supervise the liquidation of insurers that have financial problems? Is that correct, through you, Mr. Speaker?
Representative Scanlon.
Through you, Mr. Speaker, that is correct.
Representative Sampson.
I would have liked to have read through those sections just a little more clearly this afternoon, but I'm confident that this is the same language that passed out of the committee also, and that I believe that also went through with a great margin of support. So I'll just move on to section 9, which I have in my notes as the medical malpractice closed claim report. And I'd like to ask through you, Mr. Speaker, if the chairman would describe to me what this section is about and what changes are made to our current law regarding this. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, with absolute candor, the insurance department had the date that they had to give this report every year was March 15th. They routinely did not meet that goal, and they changed the date under here to June 30th to give them a little more time to make sure that they meet the standards that are set under this law and provide us with the most important information. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and forgive me, I was a little distracted having another conversation over here. If I understand correctly, this section changes the requirement for certain closed claim reports that go to the commissioner and the date by which they need to arrive. Through you, Mr. Speaker, would the chairman tell me what the change in the date is?
Representative Scanlon.
Through you, Mr. Speaker, March 15th to June 30th. Through you.
Representative Sampson.
Thank you, Mr. Speaker. My understanding is that it's from March 15th of 07 was the original date that was in this this bill. So it's actually changing it to this June 30th of next year, 2018. Through Mr. Speaker, can I just ask, because it's relevant to that section, what exactly that information is used for, the collection of closed claim reports for malpractice? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, I believe it just helps them maintain a proper understanding of what's exactly happening throughout their department and with various insurance-related matters. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. I would say that it's safe to say that they collect this data to analyze and find out what appropriate premiums are charged for malpractice insurance in the state. And nothing is more important than the actual claims experience to show exactly what's happening in the industry. So on to Section 10, which has to do with preferred provider networks. A lot of people call them PPNs. Through you, Mr. Speaker, if the chairman again would let me know what Section 10 does.
Representative Scanlon.
Through you, Mr. Speaker, basically it takes the preferred provider network and it keeps the higher minimum net worth. It raises it from $250,000 to $500,000, which we view as a good consumer protection measure that the insurance department has brought to our attention at the behest of trying to protect CT consumers. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. Through you to the chairman, I'm wondering if he can describe for me exactly what a preferred provider network is and why there would be a minimum net worth to begin with. Through you, Mr. Speaker.
Representative Scanlon.
There's a minimum net worth because they accept a portion of the risk of delivering services. So they're not a managed care organization, but they pay claims for the delivery of healthcare services. And in doing that and in paying those claims, they do accept some bit of risk. So we want to make sure that they have enough on hand to deal with paying out those claims to keep consumers protected. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. I know that the chairman mentioned that the increase goes from $250,000 to $500,000 as that requirement. I'm curious if there are any other additional requirements being placed on these PPNs in the legislation before us. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, it does change the dates of renewal and their application process. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman. I know that I saw something else in here that has to do with an amount that is equivalent to 4 months of payments versus 2 months of payments that they must maintain or arrange for reimbursements. And I just thought we should mention that also. Forgive me while I flip ahead to Section 11. I'll just continue on the same vein through you, Mr. Speaker, and ask the chairman if he'll let me know what Section 11 does.
Representative Scanlon.
Yes. Oh, yes.
Through you, Mr. Speaker, Section 11 and Section 11 through 30 is a technical change repeated 20 different times to correct a statutory mistake 20 different times in Sections 11 through 30. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. My notes say that there is something in here regarding dental HMOs, and I'm wondering if the chairman could point that out to me in the language so that I know where that section is. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, I believe it is in lines 809, 810. It is referring to the dental HMO statute in that section. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman. So just to confirm, these sections, all of them, from Section 11 through Section 30, the only thing that's being achieved in those sections are technical and conforming changes to how we treat dental HMOs in the state. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker. Section 15, 16, 18, and 19 are the ones that are dealing with the dental-specific HMO. The rest are conforming per LCO. Through you, Mr. Speaker.
Representative Sampson.
If that's the case, I will skip ahead all the way to Section 31. And again, as before, Mr. Speaker, if the good chairman would be happy to explain Section 31 to us.
Representative Scanlon.
Through you, Mr. Speaker, in the past, I believe it was last session, we passed a network adequacy bill. And in that bill, we did not include dental and vision carriers, which was an oversight. And the department understood the fact that it was an oversight and brought this to our attention in an attempt to correct this with regard to network adequacy. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. And thanks to the chairman for that answer. My understanding of network adequacy is a desire to try and make sure that there are certain medical providers in the field that are available to consumers to make sure that they have access to care. And I understand that this section is supposed to apply to dental and vision. Were these completely left out of the original bill on network adequacy that was passed I think last year, Public Act 16-205. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, that is correct. Through you.
Representative Sampson.
Thank you, Mr. Speaker. This particular part of the bill came through the Insurance Committee earlier this year also, and I'm curious to know if there was any testimony in opposition. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, I do not recall. Through you.
Representative Sampson.
Thank you, Mr. Speaker, and thanks to the chairman for that information. Just a follow-up on network adequacy. What other lines of insurance are required in this program? Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, I do not have that information in front of me. Through you.
Representative Sampson.
Thank you, Mr. Speaker. I'm looking at Section 31, and there's some reference to health benefit plans, but there's also references to other types of insurance, including workers' comp and even medical payment insurance for automobile, credit insurance, and so forth. Is those products also required to meet the network adequacy requirements? Through you, Mr. Speaker.
Representative Scanlon.
No, they do not. Through you, Mr. Speaker.
Representative Sampson.
All right, thank you, Mr. Speaker, and thanks to the chairman for that answer also. I'm moving on to Section 32. And forgive me, I didn't get to highlight that far into the bill, so it's difficult to read those sections. As before, Mr. Speaker, if the good chairman would let me know what Section 32 is intended to accomplish.
Representative Scanlon.
Through you, Mr. Speaker, Section 32 deals with the Vaccine Assessment Fund. What is that? Well, let me tell you. The Vaccine Assessment Fund, every single insurance carrier in the state pays towards a fund that then goes to pay for vaccines in the state. And there, unfortunately, is no mechanism through that an insurance carrier that overpays towards the fund can recoup the loss of that. So how it works is that every year, the insurance company tells the insurance department how many people that they cover, which obviously fluctuates from year to year. The insurance department calculates how much money all of them together would need to do to pay for the vaccine, and each carrier is charged a fee because of that. But as I said, there is no mechanism from an insurance carrier who believes that they've overpaid to recoup some of the losses. So this specifically just allows the insurance carrier who believes that they have overpaid to take their complaint to the insurance department and resolve the issue, and then be essentially given a credit back to the next year when their assessment is levied. Through you, Mr. Speaker.
Representative Sampson.
Thank you again, Mr. Speaker, and thanks to the chairman for that answer. I'm curious if there is a requirement for how much this overpayment might be before this legislation kicks in and allows an application to occur for a reimbursement of that overpayment. Through you, Mr. Speaker.
Representative Scanlon.
Through you, Mr. Speaker, I am looking for that. I believe it's 5,000. Through you, Mr. Speaker.
Representative Sampson.
Thank you, Mr. Speaker. And I just found that in the bill myself also. And we're almost done. I just want to finish up with the last couple of sections of the bill. I think section 33 is the last section that has any real significance at all. And through you, Mr. Speaker, would the chairman please describe for us what is contained therein? Through you, Mr. Speaker.
Through you, Mr. Speaker, this also just continues what is spelled out in section 32, just in enumerating the process by which an insurer can recoup the losses or the perceived losses and how the actual immunization fund works. Through you, Mr. Speaker.
Representative Sampson.
I appreciate that very much, Mr. Speaker, and I appreciate the chairman being patient with my many questions as we proceeded through the 46 pages of language. I just want to finish up my comments from the outset, which are that this is a collection of a number of bills that went through the Insurance Committee earlier this year, and my understanding was that they were going to be combined into this bill. And as I expressed, I do have some concerns with sections 1 through 3 being significantly different from what went through the committee and what was agreed upon to be before us. Because of that, I have grave concerns about being able to support the entire bill as it is. As much as I would like to, because I think this particular legislation, in large part, is beneficial to the insurance industry in our state. Something that is near and dear to me, and I think is something that is important if Connecticut is going to see an economic recovery in our future. We must do our best to make sure we support a key industry. Connecticut is known as the insurance capital of the world, and for a good reason. And it is partly because we are proactive in how we treat that industry, and we do our best to make sure that we give them the tools that we need to. But we have an obligation also as legislators who represent the people of this state to make sure their interests are protected, to make sure that consumers are looked out for, and that we are not doing things that may ultimately cause harm because we didn't do the due diligence to make sure we heard from all of the appropriate parties before making law. And to that end, Mr. Speaker, I have an amendment. It is LCO 8110. I ask that it be called and I be given leave of the chamber to summarize.
Will the clerk please call LCO number 8110? It'll be designated as House Amendment Schedule B.
House Amendment Schedule B, LCO number 8110, offered by Representative Sampson.
Representative seeks leave of the chamber to summarize the amendment. Is there objection to summarization? Seeing none, Representative Sampson.
Thank you, Mr. Speaker. So this amendment is very simple. It just eliminates sections 1 through 3 of the bill, which are the parts dealing with the captive insurance industry. I really don't want to bring this amendment forward because I don't know whether eliminating these sections is a positive or negative benefit. But because I cannot know, and because I cannot support the bill with these sections in it, I think the best solution is to advance what we know is good, what we have confidence in, what we feel the state clearly will benefit from based on our thorough process through the committee process, through the proper public hearing of the bill, the testimony provided, and decisions being made based on what's before us that we have knowledge of. The language that's contained in sections 1 through 3 has not gone through that process. And as a result, I don't know if it meets that standard or not. I would encourage my colleagues to vote in support of this amendment, understanding that we're just delaying this section until that has an opportunity to occur. There's a week to go in the session. There may be a way to bring this back to make sure that it is vetted properly, that it is beneficial. It might be added as an amendment on another bill. If I can be convinced that it is beneficial, I'd be willing to even co-sponsor such an amendment. But right now, I don't know what this is. I don't know what this is good or not. It is my duty as the ranking member of the Insurance Committee to advise my colleagues on what we should do here. And I believe the best way forward is to remove this section, vote the bill forward, and then maybe come back to this once we know better. Thank you, Mr. Speaker.
When the vote is taken, it will be taken by roll. Representative Scanlon of the 98th, you have the floor.
Through you, Mr. Speaker, I'll just be very brief. You know, I think I can speak with absolute confidence when I say that each one of us who walks into this chamber every single day is proud of the fact that we are known as the insurance capital of the world. And when we come to Hartford, especially in this difficult budget time, I think it's incumbent upon all of us to try to support this industry. And that's not a Republican notion or a Democrat notion. That should be a Connecticut legislator notion. And with that said, this provision, section 1 through 3, is something that not only is being asked of us by the insurance commissioner, not only being asked of us by the insurance industry, but is also being supported by Senator Kevin Kelly, who is one of my co-chairs in the state Senate. And as Representative Sampson alluded to, this bill, each section of this bill has portions that were passed unanimously, I believe, through our committee. This is a very important bill, I believe, for the future of a very important industry in our state. And I would urge my colleagues on this side of the aisle to vote against this amendment. And as the Speaker said, when the vote is taken, I ask that it be taken by roll. Through you. Thank you.
Representative Buckby, the 67th, you have the floor, sir.
Thank you, Mr. Speaker. How are you this evening?
Good, sir. How are you?
I am wonderful, thank you. I don't usually get up to speak much, and I'm not one to speak on insurance. It is after 11 o'clock at night, and it's a dry topic, let's be honest. Correct, sir? My concern is with a strike-all 47-page amendment at 11 o'clock at night on a Tuesday. Now, I'm not from the committee, but I'm curious as to why this circumvents the entire concept of committee to throw this out here at 11 o'clock at night. I'm concerned that this isn't doing the justice to our constituents nor to each other. It's this battleship of an amendment that rolls in to take place of what was voted on and moved forward. I have concern with this. I have concern with that process, and as a freshman, I'm really concerned about that being how things work in Hartford. I don't think that's fair to our constituents. I don't think that's fair to each other, and I think this is something that really should go back to committee, let them work it out and present it as it should be with all the vetting that needs to happen with it. Thank you, Mr. Speaker.
Thank you very much, sir. Representative Wilson of the 66th, you have the floor.
Thank you, Mr. Speaker. And I guess I will echo what has been said here already by my good colleagues on this side of the aisle. Seeing 46 pages at this late date, number one, and then number two, listening to my good colleague, Representative Sampson, who I place a lot of trust in his experience on the Insurance Committee. And living in the insurance industry myself for a good number of years, I think it might be a good amendment to carve out section 1 to 3. Thank you, Mr. Speaker.
Thank you very much, sir. Representative Betts of the 78th. No? Will you remark further on the amendment before us? If not, staff and guests, please come to the well of the House. Members, take your seats. The machine will be open.
The House of Representatives is voting by roll. Members to the chamber. The House of Representatives is voting by roll. Members to the chamber.
Have all the members voted? If all the members have voted, please check the board to ensure your vote's been properly cast. If all the members have voted, the machine will be locked. And the clerk will announce the tally.
House B, total number voting 149, necessary for adoption 75. Those voting yea 71, those voting nay 78, absent not voting 2.
The amendment is defeated. Will you remark further on the bill as amended? Representative Sampson of the 80th. For the second time, I believe, sir.
Thank you, Mr. Speaker. I don't know if this is the second time on the bill. I think it might be, and I apologize if that's the case. I just wanted to remark after this amendment failed. I think that's unfortunate because I think had this argument been given by someone in the majority, it might have been respected by everyone in the room. And I don't want to say that people on both sides don't try and follow their hearts and minds when they do things. But I think I made a very good argument for why the process matters and why it is very important if the people of this state are going to put trust in us to do their business. We need to show them that we are better than Republicans and Democrats, but we are their representatives trying to make good policy that benefits everyone. I tried to be as upfront and honest about the situation I was in when this bill came before us tonight, that I want to support this legislation, that I think that by and large it's valuable. Even the part that I tried to remove from the bill may be positive, but I have no way of knowing that. I think that's a position that anyone in this room could and should respect if they were in it themselves. So I'll just leave it at, I'm disappointed that the amendment didn't pass. And I hope that in the future, we consider what we might do in the same situation that I was in. As far as the bill goes, it does very good things. There are major components of this bill that are certainly beneficial to the insurance industry. I think the bill is going to pass regardless. But because I do not know whether the first 3 sections of this bill are going to be positive for the state, I cannot support it. So I'll be voting no, Mr. Speaker.
Will you remark further on the bill before us as amended? Will you remark further on the bill as amended? If not, staff and guests, please come to the well of the House. Members, take your seats. The machine will be open.